Hello and welcome. This webinar forms part of a series of webinars given by Mayor Brown's Global Employment and Benefits Group on the issues affecting employers who are planning a return to work or who are adjusting to carry on business in the current circumstances. It forms a part of Mayor Brown's 1000 series, providing guidance into the top 10 pivotal issues across various topics that businesses need to be mindful of in the first 100 days of returning to work. Mayor Brown's global COVID-19 response offers insight on and analysis of the virus's impact on business worldwide through the dedicated portal known as Responding to COVID-19, which can be accessed via the Mayor Brown website or by searching covid19.mayorbrown.com. We have designed the webinars so that they can function equally well as either an audio-only broadcast or accessed via a video link. We hope you enjoy the series.
Good morning and good afternoon to everyone. My name is Doraisamy and I'm a partner in Mayor Brown's Employment and Benefits practice. I am joined by my colleagues, partner Andrew Block and counsel Beth Brown, and together we will address the key issues and risks that trustees and their pensions teams are grappling with in getting back to business. We held a webinar for multinational employers in May, which discussed the employment, benefits and mobility issues and risks at a global level, in particular highlighting Brazil, France, Germany, Hong Kong, the UK and the US. You can access this global webinar via the Mayor Brown COVID-19 portal called Responding to COVID-19, which is available through the Mayor Brown website or by searching covid19.mayorbrown.com. This UK pension-specific webinar will drill down into key considerations such as furloughing from the perspective of employers and trustees, practical governance tips to operate in the new normal, scheme funding post-COVID-19 and future pensions-related developments. This webinar is part of our 1000 series, focusing on the top 10 issues that trustees, their pension teams and employers need to consider in the next 100 days. You can access the other webinars in this series through the Mayor Brown website, covering Brazil, France, Germany, Hong Kong, UK employment, US employment, US benefits and global mobility, or by searching for covid19.mayorbrown.com.
Thank you very much, Jay. As Jay said, my name is Andrew Block and I'm a partner in our London pensions team, and I'm going to be talking about furlough and pensions. Many of you will have taken advantage of the government's furlough scheme to put staff on furlough, or you may have your own furlough scheme, or might be topping up the government's furlough scheme with additional payments. It's worth noting that no new employees can be put on the government's furlough scheme. The scheme closed to new joiners on 10th of June. Under the government's coronavirus job retention scheme, an employer can currently claim 80% of an employee's PAYE salary, excluding bonuses, up to a maximum of £2,500 per month for a full-time employee and prorated for part-time employees. Employers can also claim for national insurance contributions and for minimum pension contributions. The scheme is winding down. From the 1st of August, employers will no longer be able to claim national insurance contributions or pensions contributions. For September and October, the amount the employer can claim and the cap are both reducing, and the government has said that it intends to end the scheme at the end of October. Until 1st of June, employees had to be furloughed in 3-week blocks and could not do any work for their employer whilst furloughed. But from 1st of July, employees can be brought back to work at any time and for any shift patterns. So employers can only claim pension contributions for work up to 31st July. The pension contributions which employers can claim for work up to 31st of July is the pension contribution which they are required to pay under the automatic enrolment legislation. This is calculated differently depending on whether employees are weekly or monthly paid. But for most monthly paid employees, the contribution is 3% of the employee's basic monthly salary, with that salary being capped at £2,500 and being subject to a £520 deduction. So, to give an example, if an employee is earning £4,000 per month and is furloughed for the full month, the maximum claim is 3% of £1,980, which is £2,500 less £520, which is £59.40. The claim will obviously be less if the employee is not furloughed for a full month or is part-time. That's what you can claim, but what you have to pay is different. If an employee is back at work part-time, i.e. some days the employee is on the government's furlough scheme, other days the employee is working, then for days on which the employee is working, you have to pay the full employer pension contribution required by your scheme's rules. If an employee is on furlough, then what you have to pay depends on whether you are paying into a defined benefit or a defined contribution scheme, and whether you're operating salary sacrifice. If you are paying into a defined contribution scheme, then employer and member contributions are likely to be based on what the employee is actually receiving, but you need to check the definition of the member's salary for the purpose of member and employer contributions in the rules. If you are operating a defined benefit scheme and members are paying contributions to it, again, these contributions are likely to be based on what the employee is actually receiving, but again, check the definition of salary used for member contributions in the rules. Your contributions as an employer, whether to pay for ongoing accrual or to pay off deficit, are also likely to be based on what the employees are actually receiving, if those contributions are expressed as a percentage of the member's salary, however that is defined in your rules. But you do need to check your rules, because there are sometimes quirks or anomalies which may mean that you have to pay something different. You should also check your schedule of contributions to see what that says about how employer contributions, and in particular deficit reduction contributions, are calculated. In particular, it's becoming more common to see deficit reduction contributions expressed as cash lump sums in the schedule of contributions and in recovery plans. And if this is the case, as an employer you have to pay the sum stated. We will talk about the Pensions Regulator's guidance on deferring contributions a bit later in this webinar. What will members accrue? For a defined contribution scheme, this is easy, whatever the reduced employer and member contributions are. Defined benefit schemes can be more tricky. Many, but not all, contain detailed provisions about what happens if a member's pay reduces and the effect that this has on their final pensionable salary. Many also contain detailed provisions setting out what happens if an employee has a break in service. Note that a furlough will not usually be a break in service for pension purposes, but again, you need to check your rules for the details. This is one area where it is worth getting specialist advice, because every set of rules is slightly different. There are a few other issues to be aware of. Firstly, redundancies. Some final salary schemes, particularly in industries which used to be nationalised, contain generous redundancy provisions. These can sometimes be expressed so that employees who are not yet at an age when they can draw their pension can benefit from an enhanced pension when they do draw it. So, for example, in one scheme we act for, an enhanced redundancy benefit is provided to members aged 45 and over, even though a 45-year-old cannot draw an immediate pension. Other funnies can include some ex-public sector schemes and schemes which mirror public sector schemes which contain a rule of 85. If the member's age plus service equal or exceed 85 years, the member can become entitled to an unreduced pension paid early on leaving service. Sometimes the rules are expressed so that generous retirement benefits are triggered by members leaving service in circumstances which are not technically redundancies. For example, some ex-public sector schemes have wording which provides an enhanced pension on dismissal for the efficiency of the service, or similar wording. All of this can increase the costs of redundancy exercises, but they can also sweeten the pill for members who benefit from these provisions. Sometimes the cost of the additional benefit has to be paid up front by way of a special employer contribution, and sometimes it feeds into the next actuarial valuation. Every set of rules is different, so you need to take advice. Secondly, changes to terms of employment, or switching to using temporary or agency staff. The automatic enrolment legislation applies to certain agency and temporary staff, and switching employees to part-time employment can have pension implications, particularly if they are accruing benefits in a defined benefit scheme. The details of what can happen depend on the particular circumstances and are beyond the scope of this webinar. The takeaway for the present is that part-time and agency staff can have pension rights, and it is worth taking advice. Finally, and apologies for ending on a morbid note, deaths in service and long-term ill health. A few quick points here. You might want, tactfully, to suggest to employees to whom you provide life assurance that they keep their expression of wish forms up to date, so that if the worst happens, any lump sum payable on their death goes to those they wish to protect. It may also be worth checking with your insurance broker that deaths caused by COVID-19 are covered. So far, we have not seen any life assurers insisting on particular social distancing measures in workplaces as a condition of extending cover, but this has been an issue for schools. And lastly, if you offer permanent health insurance as well as a final salary pension, it may be worth checking to ensure that the two mesh, so that employees on long-term sick do not receive PHI payments on top of a generous ill health pension from the pension scheme. That's all from me for the moment. I'll now hand over to Jay, who will talk about governance.
Thank you, Andrew. I'm now going to cover some specific governance issues which we have seen arise quite frequently recently. Many pension scheme trustees, particularly larger ones, will be using their delegation powers to delegate some of their powers to trustee subcommittees to either review certain matters and make recommendations to trustee boards and/or to make decisions themselves at committee level. Provided the remit and role of the subcommittees is clearly scoped and documented, this approach can work very well. It does make for efficient operations and allows the trustee board to really focus on strategic matters. However, the COVID-19 pandemic has brought home an important point, which is that it is quite possible that there may be circumstances where a trustee board, for one reason or another, finds itself unable to function, even where they already have subcommittees in place. You may have already considered this, and you may have already put in place procedures to cope with this type of scenario. An example is that it might not be possible to achieve a quorum, either at trustee board or subcommittee level, and/or there might be a lack of trustee availability. There may be multiple absences due to illness or other factors, or the means of communication may simply just not be there. Importantly, it is not just a pandemic that could cause such an issue. There could be other serious situations that impact on the ability of trustees to carry out their work. We already know that COVID-19 may be here to stay for some time. There is also the possibility of future different pandemics. A major security incident, an IT meltdown, a significant cybersecurity attack, the outbreak of conflict are just some of the other types of situations that could give rise to problems for trustee boards. So are your trustees and pensions team equipped to function in these circumstances? It might be possible to somehow soldier on, but there are risks in doing so, and those risks could be significant. In any of the circumstances mentioned just now, there is a heightened risk of legal and regulatory breaches due to the processes not being in place to make the decisions that need to be made. This can potentially impact on funding and investments, result in a failure to comply with statutory deadlines or requirements, and give rise to member complaints, just to name a few of the broad implications. A way in which you can manage this situation is to put in place a committee that is empowered through delegated authority from the trustee board to operate in just such a scenario. It's commonly called an emergency powers committee, but of course you can call it anything. The primary objective of such a committee would be that if any of the scenarios should arise, then the powers of this committee could be triggered. You will need to check the terms of your scheme's trust deed, and if you have a trustee company, then you need to check the Articles of Association, so you delegate within the terms of your governing documents. If necessary, you could amend them. If you do decide to put in place an emergency powers committee, you need to ensure that the way in which it operates is very clear and that its terms of reference are approved by the trustee board. You could also shape it along the lines of any of the current subcommittees to the extent that this is going to be helpful. Areas which should be covered in the Emergency Powers Committee remit include the following. Some background explaining why it exists and its objectives, examples of situations in which the committee could be required to operate. These will not be business as usual circumstances. How the terms of references can be amended. This should be with the trustee board agreement, of course. Who decides that the Emergency Powers Committee should be triggered? In other words, what is the mechanism for it to come into operation? I would expect it to be more usual for the Chair of Trustees to decide this, but if he or she is not available, you can consider cascading down to the chairs of the current subcommittees. Other areas you will want to cover in an Emergency Powers Committee remit will include areas such as what is the quorum, what is the decision-making process, and of course you may wish to set out a number of other procedures. I'm now going to cover another governance area, which is in relation to meetings and signature of documents. Over the last few months, trustees and pension teams have had to adapt very quickly to the use of virtual meetings. In fact, I've even heard comments to the effect that it can be more time efficient to have virtual meetings than face-to-face meetings. We need to see how these practices evolve, but clearly there is a new norm for pension schemes for some time yet, and an evolution as to how schemes are going to operate in the future. However, as always, do ensure your virtual meetings comply with your trust deed and, if you have a trustee company, your articles of association. What powers do the trustees have to hold virtual meetings? Are there any restrictions? Or do you have full power to determine how your meeting operates? You would usually have broad terms to decide the manner of your meetings, but I think it's always worth checking this for good order. The changes in the way pension schemes are operating do present opportunities. For example, you could consider ways to use virtual meetings as a means to streamline the agenda and refocus trustee business, such as more focus on strategic matters at trustee board level and a reconsideration of subcommittee terms of reference and delegations. Virtual meetings can be made to operate very differently from face-to-face meetings. In practice, it is useful if attendees introduce themselves before they comment or contribute at a virtual meeting. I think this is particularly important for the minute taker and the minutes, and this should apply to all attendees, including the advisors. Of course, if the numbers are small and you are on video conference, this might not be necessary. I just want to turn to trustee training now. This is an area that can get neglected in the current circumstances, and it is understandable why that might be the case. The focus has just been on more pressing issues. That's been the reality of life over the last few months. Often, training has taken place during trustee meetings, and there's no reason why this should not continue to be the case. However, it is worth reminding ourselves of the importance of keeping up to date on developments and being able to demonstrate that you are undertaking training, with the training registered in the training log. The Pensions Regulator, as you know, has been increasingly focused on trustee training, and whilst it is not requiring CPD hours, it has suggested 15 hours for lay trustees and 24 hours for professional trustees per annum in its consultation response to the future of trusteeship and governance. We are seeing many trustees over the last few months really plan to put in place structures around how trustees can meet a certain number of hours. And there are a number of options for trustees to achieve this. For example, as mentioned, you can add them to your virtual meetings. You could have a short session at the start, for example. You can hold them outside of your virtual meetings as a bespoke session. You can tune into webinars, such as this one, do reading, for example, legal updates and articles that you receive, and attend virtual trustee training for a wider audience. there are lots of options available to you. Just check with your advisors and check externally as to what's available in the wider pensions industry. I now want to turn to another practical matter, which is how do you get your documents signed in the middle of a pandemic and lockdown if trustees or authorised signatories are not able to provide a hand signature, what we often call a wet signature? You will be used to signing in person, so it is important to understand what you need to do if a wet signature is just not possible. At this point, I would stress that you need to check this with your legal advisor. For example, the last thing you want is to find that a deed purporting to make a rule change has not been properly executed. The first thing you need to bear in mind is that there are different requirements depending on the type of document you need to get signed. Under normal circumstances, all contracts should be signed using wet ink signatures. However, there will be circumstances where this is not possible or appropriate, for example, during an extended period where trustees are required to work remotely. In these circumstances, trustees may agree that for particular contracts or for all contracts executed during a particular period of time, electronic signatures can be used. Deeds cannot generally be signed electronically, but there are alternatives using electronic signatures that can be considered, particularly in light of the current circumstances. But I would urge you to get legal advice to make sure that this is done properly. Again, check your trust deed, or if you're a trustee company, check the Articles of Association in case there are any restrictions on signing methods. There are different forms of electronic signature. A Law Commission report last year on the signing of electronic documents did not require a specific method for executing an electronic signature, but suggested that an electronic signature may take many different forms. You could have scanned a handwritten signature that is incorporated into an electronic document, or paste an image of a manuscript signature into an electronic document. You could use a stylus or a finger to sign an electronic document via a touch screen or digital pad, or you could use a web-based e-signing platform such as Adobe Sign or DocuSign to generate an electronic representation of a handwritten signature or digital signature using PKI cryptography, which is backed by a digital certificate from the platform to verify the signatory's identity and link the signatory to their public key. Therefore, trustees need to decide what process to follow when an electronic signature is used. For example, written resolutions can be circulated by putting the text of the resolution into the body of an email, and they are agreed unanimously, and so each trustee director signs the resolution electronically by replying to the email with the words, "I confirm that I agree with this resolution," with their name typed underneath. For contracts, instructions can be given when the contract is circulated for signature. Either of the following methods may be used, unless the contract itself specifies an alternative: scanning a handwritten signature into the document or using e-signing platform. Make sure that electronic signatures will be authenticated. Secure email systems must be used for the circulation of all documents to be signed using electronic signatures. Finally, from a governance perspective, you may wish to consider putting in place a signing policy so that there is clarity as to how to deal with the signing of documents in the current circumstances. Above all, please do remember that the documents you sign have significant implications for your pension scheme. It is therefore really important that attention is paid to the proper execution or signing of documents, not to mention ensuring that where required, signatures are properly witnessed. I'm now going to turn on to another governance area, which is to do with transfers out. Pension schemes have had to tread the line between providing DB transfer requests where a member has a statutory right to a transfer of a cash equivalent transfer and potential pension scams. This really hasn't been an easy task with DB to DC transfers. With the COVID-19 pandemic, there has been an increased activity by pension scammers, whether through scam schemes or dubious high-risk investments. The Pensions Regulator, as you can imagine, has taken a very keen interest since the lockdown began and has issued specific guidance in this area. In particular, it wants trustees to keep members informed about the heightened risk of scams in the current environment, and that it is unlikely to be in members' best interests to make a transfer. Therefore, trustees should consider communicating the risks to members, and if they have, consider if further and/or periodic reminder should be sent. It is more practical to consider this in the context of any planned communications, for example, if you have an annual newsletter due out to members. When a request is made, then do ensure you provide prominent risk warnings in the transfer packs and any other documents that you issue. Do also remember to send these warnings directly to the member, and do not rely on the member's advisor passing it on to the member. It is also prudent to review your transfer processes to make sure they are robust and compliant with the regulator's requirements, and also the Code of Good Practice on combating pension scams, which contains a number of useful practical steps for trustees to take in carrying out due diligence around the transfer process. Think about how you can build these best practice steps into your own processes. Now is a good time. Above all, you should seek to demonstrate that you have robust processes in place and evidence them should you ever need to. Do check the position with your pensions administrators or in-house administrators as well. The regulator sees trustees as being the first in line to combating pension scams, and so with this in mind, taking suitable steps to review what you're doing is important in helping to protect your scheme members. The final point I'd like to make is that if you implemented a 3-month delay to transfer requests, as the regulator allowed, then you will now need to be progressing those transfer requests and ensuring that you communicate accordingly to members. The regulator allowed schemes to make use of the flexibility in the legislation to extend the time to provide cash equivalent transfer value requests by 3 months. You will recall that the regulator identified that COVID-19 may cause 2 problems for trustees of DB schemes. First, calculating cash equivalent transfer values may take more time, as trustees may wish to revisit the basis on which they are calculated. Secondly, some schemes may see an increased demand for cash equivalent transfer values at the same time as facing shortages of administrative staff. The regulator has said in its guidance that it expects trustees to be able to report any breaches of their transfer obligations from 1 July 2020, and that they will take a pragmatic approach to breaches caused by COVID-19 issues. I'd also like to add to this that you should review the regulator's guidance on communicating to members during COVID-19 so that your scheme is fully up to date with the regulator's expectations on member communications at this current time. In particular, if you operate a DC scheme, members' behaviours are likely to be in part influenced by the current situation. For example, members may look at opting out, transferring their DC pots, or switching their investments. Given these possibilities, trustees need to highlight a number of points to members by contacting them about a number of points as flagged by the regulator. For example, you should consider covering what current market volatility might mean to members retiring over different future time periods, how members need to think carefully and consider getting investment advice before switching funds in the current market to avoid crystallizing losses, and the danger of scam activity in the current climate. And finally, that free, impartial guidance is available from the Pensions Advisory Service. That's all I wanted to say about governance, and I will now hand you over to Beth Brown.
Thanks, Jay. As mentioned at the start, I'm Beth, counsel in the London Pensions team, and I will be talking to you about some key funding developments. The economic impact of COVID-19 will be felt for a long time, and it is likely that many businesses will struggle, having had to deal with a significant drop in revenue over the past few months. Where businesses are struggling financially, actions an employer may seek to take include asking the trustees to agree to a contributions holiday or to lower employer contributions, borrowing money on more onerous terms or increasing its existing debt, and or restructuring its balance sheet or the operations on an urgent basis to avoid insolvency. Trustees will need to be prudent when dealing with the employers in these circumstances and ensure that they are maintaining a balance between making sure that the scheme remains well funded in the short term and keeping a strong employer which will be beneficial in the longer term. When employers make any request to the trustees should be wary of immediately saying yes or no. Instead, the trustees should ensure that the employer provides them with all the information that they need in order for them to be able to make an informed decision. Throughout this process, employers should also be keeping trustees informed of any discussions that they are having with other stakeholders, such as banks, suppliers, and other creditors, to ensure that the trustees have a clear understanding of the position of the pension scheme in relation to the overall picture of the company. The most common request from an employer is likely to be to reduce contributions or take a contributions holiday. When considering such a request, the trustees should consider whether 1. The holiday exceeds 3 months, and having been able to review the employer's overall financial position, whether the need for the reduction or suspension of contributions can be fully justified. 2. Whether there is an appropriate plan in place for the payments that are deferred or not being paid in full to be caught up on, bearing in mind that, ideally, any recovery plan that is already in place should not be lengthened. And 3. Whether the scheme is being given equitable treatment to other stakeholders, and indeed, the trustee might want to enter into legally binding agreements to ensure that other distributions, such as dividend payments, are not going to be paid out during the contributions holiday. The Pensions Regulator has been especially keen to emphasise the importance of the final point, because schemes should not be treated as a creditor of lower importance. It will be important for trustees to balance the short-term scheme funding position with the need for a strong employer covenant in the long term. I will move on to the Pensions Regulator's annual funding statement next. The 2020 statement was released in April this year and is primarily aimed at schemes with valuation dates in the period from 22nd of September 2019 to 21st of September 2020. But it's also relevant to any pension schemes which are experiencing significant changes and are having to review their funding and investment risks. As you would expect, the statement repeats and expands on many aspects of the recent COVID-19 guidance issued by the regulator. The focus on the long-term target plans is in line with the proposed legal requirement in the Pension Scheme Bill for trustees to have long-term strategies and reflects the DB Funding Code consultation. Many trustees and employers will be familiar with the key messages in the statement and will already be meeting the regulator's expectations. Nevertheless, these are highly challenging times for trustees and employers, and a joined-up approach will be key to achieving positive outcomes. The scheme-specific issues for trustees and employers of defined benefit or DB schemes to consider include considerations in respect of the valuations. Whilst trustees who are close to completing their valuation are not required by the regulator to take account of post-valuation experiences, trustees are expected to consider post-valuation experience in their recovery plans, with a focus on employer affordability. Also, trustees thinking of changing their valuation date due to the unusual market conditions should really consider this carefully, particularly whether this is actually in the interest of scheme members and how such a change will impact on the security of members' benefits. And finally, on the valuation point, for schemes with March and April valuation dates, it may be reasonable to delay making decisions about technical provisions or TPs, as TP assumptions should be based on a range of potential future outcomes and the different paths of economic recovery. Moving on to recovery plans, trustees should carry out due diligence on the employer covenant as set out in the regulator's COVID-19 guidance and plan any deficit recovery focusing on the affordability, fair treatment and sustainable growth of the employer. The regulator also expects trustees to apply incremental additional contributions linked to appropriate triggers or investment returns that track the employer's corporate health. As mentioned earlier, where trustees have agreed significant reductions in contributions to support the employer, the trustees should consider various factors, including how these deferred contributions will be repaid. The statement also sets out the regulator's expectations of trustees. These include schemes with long-term funding target plans, focusing on those plans, but just with short-term modifications that take account of the current environment. When assessing the employer covenant, trustees should take account of COVID-19, as well as the likelihood of the UK leaving the current transitional period with the EU in December this year without there being a UK-EU trade deal in place. Trustees are also expected to significantly increase their due diligence on the employer covenant until such a time as covenant visibility and strength is restored. Contingency planning and covenant tracking with appropriate triggers and thresholds put in place are encouraged. And finally on this slide, the current environment does not change the fact that trustees are expected to continue focusing on integrated risk management. As was the case last year, the regulator has produced tables setting out the key risks that trustees and employers should be focusing on, although they're not exhaustive. Scheme maturity and high levels of transfer activity are specific risk areas that are mentioned. Moving on to the Retail Price Index, or RPI, a long-awaited consultation has been launched on the reform of the RPI. The UK Statistics Authority has a legal obligation to maintain the RPI, and the government has no intention of changing this at the moment. However, in recognition of the questions that have been raised about the effectiveness of the RPI in current times, the government is considering amending the methods and data resources used for the RPI by bringing it closer to those that are used for the Consumer Price Index plus housing costs, which is more commonly referred to as the CPIH. CPIH has been the government's lead measure of inflation since March 2017. The government's consultation comes in the wake of several high-profile court cases, including those involving Arcadia and Barnardo's, in which the sponsoring employers sought, unsuccessfully, to change the scheme's inflation index from RPI to CPI in order to reduce the amount that is payable to members and, in turn, by the employer to the scheme. The most recent case considering this involved the Arup UK pension scheme. In this case, it was highlighted that the RPI has not been replaced, as the RPI would only be replaced if it was discontinued and another similar index was introduced and declared by the Office of National Statistics to have taken its place. The government's consultation opened on the 11th of March and was originally expected to close on the 22nd of April, but in light of the disruption caused by COVID-19, this has been extended to the 21st of August. RPI usually runs approximately 1% higher than CPIH. However, due to the economic impact of the current crisis, RPI and CPIH are currently much closer together, with RPI at 1% and CPIH at 0.7%. From a pensions perspective, reducing RPI would mean that members of most DB schemes would receive lower pension increases if their pension increases were linked to RPI, and therefore schemes would have to pay out less to these members, and on the face of it, deficits would be reduced. However, it could also reduce the value of scheme assets if trustees hold a lot of index-linked gilts. For example, according to the research by the Pension Policy Institute, DB pension schemes hold approximately 470 billion of RPI-linked bonds. And that same research estimates that schemes that are heavily invested in index-linked gilts would experience a drop in overall scheme assets of 17 million per 100 million invested if the RPI reforms took place in 2025. The government is keen to hear views on the potential impact of changes being made to the RPI, as it's currently unclear. The research by the Pension Policy Institute is just one of the analysis out there at the moment. The government wants to balance the interest of the holders of index-linked gilts and the impact of making the proposed changes on public funding. I will now hand back to Jay, who's going to talk to you about the investment disclosures.
Thank you, Beth. We're now going to move on to some future matters, starting with investment disclosures. The first area, investment disclosures, is just around the corner, and I know many of you will be preparing for this now. The first area covers changes to the Statement of Investment Principles from 1 October 2020. Trustees need to be updating their SIP to include a number of things. For example, they need to cover the policy on arrangements with asset managers in respect of areas such as incentives, remuneration, portfolio turnover and duration. You also will need to include in your SIP more information on engagement activities in their stewardship policy. The DC default arrangement SIP must also include additional information such as the policy on arrangements with the asset manager, and it has to include a wider range of information on engagement activities. The other area on investment disclosures is relating to the annual report and accounts from 1 October 2020. The investment section of the annual report needs to include the policy on asset manager arrangements, and it needs to also include detail on the stewardship of scheme investments. In addition, the SIP implementation statement has to be published on a website, and the annual benefit statements must state that implementation statements are publicly available on a free-to-access website. Finally, on investment disclosures, I just want to mention that whilst we're covering the Pension Schemes Bill in the next slide, I want to flag that at this stage, the Pension Schemes Bill currently provides 4 regulations to be published that require pension schemes to provide information on climate change risks and that impose governance requirements in this area. So it's an area that you do need to keep an eye on, and it will be developing. Over to you, Andrew, on the Pension Schemes Bill.
Thank you, Jay. I'm only going to touch briefly on the Pension Schemes Bill. It's a talk, in fact several talks in itself. The bill began its report stage in the House of Lords on the 30th of June. It then has to go through the House of Commons, and we don't yet know when the bill is likely to receive royal assent or to come into force. The main features of the bill are listed on the slide, but in the interest of time, I'm only going to pick out 2 of them. Firstly, the new criminal offences. The bill will create 2 new criminal offences in relation to defined benefit pension schemes. The first is if a person does an act, which includes a failure to act, or engages in a course of conduct that prevents the recovery of the whole or any part of a statutory debt due to a pension scheme, prevents a statutory debt from becoming due to a pension scheme, compromises or settles such a debt, or reduces the amount of such a debt which would otherwise have become due, intending the act or course of action to have that effect, and without reasonable excuse. The second is if a person does an act which again includes a failure to act, or engages in a course of conduct that detrimentally affects in a material way the likelihood of accrued scheme benefits being received, where the person knows or ought to have known that the act or course of conduct would have that effect, and again where the person does not have a reasonable excuse. Both of these offences carry a maximum penalty on conviction of an unlimited fine and or 7 years imprisonment. And the bill goes on to give the Pensions Regulator the power to levy civil penalties of up to £1 million in similar circumstances. The wording of these offences is very wide and potentially catches behaviour for which the regulator cannot impose a contribution notice. The regulator can only impose a contribution notice on people who are associated or connected with an employer in a defined benefit pension scheme, but the criminal offence can be committed by anyone. However, we think that the Pensions Regulator is likely to take a similar approach to prosecuting these offences as the FCA takes to prosecuting similar offences under the financial services legislation, not least because the Pension Regulator's current head of enforcement is ex-FSA. Any prosecution would be in a Crown Court before a jury, and the court would need expert evidence on what reasonable excuse means in a pensions context, which is likely to involve expert evidence and consideration of the examples given in pension statute and regulator guidance of reasonable and unreasonable conduct. And when deciding to prosecute, the regulator will also apply the two-stage test under the Code for Crown Prosecutors. This is on the evidence before the prosecutor. Is it more likely than not that the jury will convict, bearing in mind the standard in a criminal trial is beyond reasonable doubt, and is it in the public interest to prosecute? The regulator will probably also have regard to Section 6.2 of the FCA's Decision, Procedure and Penalties Manual, which sets out the procedure the FCA follows when deciding whether to take action and if so what to do, and also whether the regulator could impose a contribution notice against the individual concerned. This, taken together, is likely to mean that prosecutions will be few and far between, and limited to circumstances where there has been behaviour which a jury will consider to have been criminal, not circumstances where honest people were doing their best but arguably fell the wrong side of the line. Having said this, the regulator, like the FCA and in some circumstances like HM Revenue and Customs, will almost certainly use the threat of prosecution to influence behaviour and to secure payments to pension schemes where schemes have been disadvantaged by corporate behaviour. So this is very much a watch this space. The other element of the bill I would like to touch on is the new oversight regime for corporate transactions. The bill will require certain persons involved in corporate transactions to tell the Pensions Regulator about the transaction and how any detriment to a defined benefit scheme caused by the transaction will be mitigated. In perhaps the majority of cases, this is likely to have the effect of giving trustees of defined benefit schemes a seat at the table when corporate transactions are discussed. So much for the Pension Schemes Bill. I'm now going to hand over to Beth, who will talk about insolvency.
Thanks, Andrew. The Corporate Insolvency Governance Act 2020 aims to help companies avoid insolvency during economic uncertainty. It received royal assent just last Thursday, having passed through Parliament very quickly, to allow its provisions to be used by companies experiencing financial difficulty as a result of the COVID-19 crisis. From a pensions perspective, the key provisions of the Act relate to the new moratorium and restructuring plan. I will talk about each of these in turn. The new moratorium is a period of 20 business days, although this period can be extended, in which a struggling company is granted payment holidays on most forms of debt and is protected from legal action. During the moratorium period, creditors will not be able to take any enforcement action against a company without the explicit permission of the court. The Act also introduces a new restructuring plan process where if a company has encountered financial difficulties that affect its ability to carry on its business as a going concern, it can agree a compromise with its creditors with the aim of helping it to continue as a going concern. The court can sanction a restructuring plan provided that the plan would not leave any of the dissenting classes of creditors worse off than if the company had chosen a relevant alternative method. Neither the moratorium or the restructuring plan will be qualifying insolvency events under the Pensions Act 2004 meaning sponsoring employers of eligible schemes who use these new mechanisms will not trigger a pension protection fund or PPF assessment period. This raised some concerns in the pensions industry that the moratorium and restructuring plan would detrimentally impact pension schemes. To try to address this, the Act was amended so that both the Pensions Regulator and the PPF must be notified of a moratorium or restructuring plan. Further, if a company is an employer of an eligible pension scheme and the trustee is a creditor of that company, the PPF will be able to bring a challenge against a moratorium arrangement on behalf of the trustee in accordance with insolvency rules, and where a compromise or arrangement is proposed in respect of that company, the Act makes provisions for regulations to be passed which would allow the PPF to exercise the trustee's rights as creditor. Hopefully we'll have more detail on this soon. I will now hand back to Jay, who will conclude this webinar.
Thank you very much, Beth. Well, that brings us to the end of the session, and I'd just like to say if you have any questions at all, please contact any of us. Our details are on this slide. Andrew, Beth and I would like to thank you very much for joining us, and I hope you found it helpful. As I just said, do let us know if you've got any queries. If you would like any information similar to this in relation to one of our other jurisdictions, do let us know by contacting your usual Mayor Brown contact or emailing our events team. Thanks again for listening, and we look forward to you joining our future webinars.
Thank you for listening. We hope you found this useful. This series forms part of Mayor Brown's 1000 series, providing guidance into the top 10 pivotal issues across various topics that businesses need to be mindful of in the first 100 days of returning to work. If you have any questions, please get in touch with any of the speakers or your usual contact at Mayor Brown, and we will be happy to follow up with you directly. For the latest COVID-19 related legal developments, please do visit our dedicated portal called Responding to COVID-19, which is available through the Mayor Brown website.